Okay, before we move on, trying to incorporate a lot more active learning into our curriculum, so let's take a break here from substantive, doctrinal type videos and take a look at some questions for practice. I'm going to post 3 practice questions. Hopefully it'll be clear to you what they're on, especially if you've looked at the issue spotting video for, well, the issue spotting video I posted. I don't want to give away any answers here, but what I want to do is go ahead and start this off. Then I will post the questions. I will insert those, embed those into this video. You'll want to click pause, take a few minutes to look through the questions, pick what you think is the right one, and then I will review them one by one. So here are the questions. Okay, we're back. Let's dive right in to question number 1. A U.S. District Court judge has issued a nationwide injunction against the enforcement of a travel ban imposed under an executive order issued by the President. Immediately after the judge ruled from the bench, the lawyer for the government, I guess that's redundant, immediately asked for a stay of the order. The judge denied their request. The result of the judge's order under these circumstances is: A, the government may continue to enforce the ban if it intends to appeal. B, the government must stop enforcing the ban immediately. C, the government's lawyer has committed malpractice. Or D, the case may now be appealed to the U.S. Supreme Court under that court's original jurisdiction. Okay, you should have picked B as the best answer under these circumstances. As to A, no. Again, if there is, all federal courts have the power of judicial review. If a federal court issues an order, then that order has immediate effect unless there's a stay on it. So if there's a judgment from this court and the judge has explicitly denied a request for a stay, then certainly the government is not at liberty to go ahead and enforce it pending appeal. The order is only stayed pending appeal if the court stays. Now, just so you know how this works, if I'm a government lawyer and I ask district court for a stay and the district judge tells me to go pound sand, then I'll pound sand all the way to the Court of Appeals and try to get them to put a stay on the district court's order, right? So you can go up the ladder trying to get a stay, but unless there's a stay on that order, it has immediate effect. B is correct. It's kind of conclusory, but the instructions on multiple choice questions, either on my exam or the bar exam, are to pick the best answer, and if the best answer is a conclusory answer, then so be it. Here, the other 3 answers are quite bad. C is completely inapposite, right? What does that have to do with anything? And D is really a bad answer, right? You don't appeal to the Supreme Court under its original jurisdiction, right? Original jurisdiction means the first court to hear a case. So D would be a really off-the-wall answer. So the best answer here is B. Let's move to the second question. Congress passes a law called the Viral Infection Minimization Act, VIMA, under which a person infected with a contagious virus may sue the person who infected him or her if that person did so recklessly. Under VIMA, the suit must be filed in a U.S. District Court, and after conducting an evidentiary hearing, the district judge will issue a recommendation to the U.S. Secretary of Health and Human Services, HHS, who will make a final determination on liability and damages. This arrangement is A, a valid delegation of judicial authority to the executive branch, B, a valid exercise of the judiciary's power to provide advisory opinions, C, invalid but only because the Secretary of HHS rather than the President makes the final determination, or D, invalid because it is not consistent with principles of judicial review. Now again, these kind of red flag videos that I'm hoping to do more of throughout the term. I posted one under the week 1 module, maybe I'll also post it in the week 2 module so you don't miss it. Has guidance in there about how these issues can be tested. And as I said in that video, you would think that judicial review is something that's very hard to test. How would you test that? But you see here, it is possible to test it. There are now 2 questions there that test judicial review. When you see Congress trying to create some kind of scheme here where a federal judge's order is merely, basically it amounts to advice, where it's not enforceable on somebody else, unless somebody else says it's enforceable. In other words, somebody else has the option whether to enforce it or not. That is not what courts are here to do. They do not give advisory opinions. They issue orders that resolve cases and controversies under Article 3. Therefore, the best answer is D. You should have picked D. Okay, on to number 3, the third one. The U.S. Supreme Court holds that the state of Florida may not require that families cohabitate in units of fewer than 6 people to avoid the spread of dangerous viral disease. You see a theme running through these. The court holds that such a rule is a violation of the Due Process Clause of the 14th Amendment. The Attorney General of Georgia asks you, a research assistant, whether Georgia may continue to enforce an identical requirement, so Georgia also has a statute, like Florida, that bars cohabitation by 6 or more persons. After all, the Attorney General says Georgia was not a party to the lawsuit in which the Supreme Court held that this practice was unconstitutional. The best advice would be to A, stop enforcing the Georgia law because the Supreme Court has ruled on a federal question and that ruling binds all state actors. B, continue to enforce the law because the Supreme Court's ruling only binds the parties to the lawsuit. C, argue that the 14th Amendment applies differently to Georgia than in Florida under the doctrine of sovereign distinctions. Or D, seek guidance from Georgia's state courts to the effect of the Supreme Court's ruling on Georgia. Okay, so this is not a question about judicial review, it's a question about judicial supremacy. You see how this works. I often think, sometimes actually students say, oh, I thought it was a trick because it tracks so closely. I mean, there are only so many ways, and we're really trying to get that bar exam pass rate up. There are only so many ways to ask questions about these, and they're usually going to track. You just have to be able to fill in the blanks, Would I change the name of a state, but give you the name of a state or the name of a law, or but I give you basically the same thing happening. You have to be able to spot that. Here, this is like school districts in Arkansas saying that they don't want to go along with Brown versus Board of Education, right? Because they weren't a party. I gave you an example in the video that there was this county clerk in Kentucky, Kim Davis, right, who said she's not going along with Obergefell, even though the court said denying same-sex couples marriage licenses violates due process. Well, I wasn't a party to the lawsuit. You see the same exact argument here. The Supreme Court says something, right, strikes down another state's law, says that that law is unconstitutional. We have exactly the same law. I'm just going to keep enforcing it because, right, I wasn't a party to that lawsuit. So that isn't going to fly under the doctrine of judicial supremacy. If there is some way to argue that Georgia's circumstances are radically different than Florida's, I mean, maybe you can make an argument. But the question here is, what is the best advice to give? Right. So you should have answered A. A would be better. Once again, this is how it works. We don't always give you the perfect answer. Sometimes you just have to pick the best answer. A would be better if it said judicial supremacy in it. That would make it easier to see that that's the right answer. It doesn't say judicial supremacy, but it means judicial supremacy. I'm going to talk to you later in the term more about that. You can be tested in multiple choice questions at multiple layers, right? You can be tested on just what is the name of the test. You can be tested on what is the definition of the test. You can be tested on how specifically the test applies to the fact pattern right, that's in front of you. There are multiple different levels at which multiple choice questions can test your knowledge and your ability to reason through a question. As Lainey decides that once again this is time to play. So, so the best answer for number 3 was A. So that's a short video, just a little bit of review to show this isn't, again, it's not pie in the sky stuff. It's stuff that you can apply in certain questions. We'll do a little practice like that throughout the term. Self-assessment, right? That you're able to identify, hopefully, any areas where you're having difficult spots. So, as always, stay safe and stay tuned.